Hello students, I am Radhika Chitkara and I work as a legal researcher with an NGO on gender and human rights. We return to our module on human rights lawyering. Through this lesson, we will delve a little deeper into human rights lawyering and the experiences that we can gain from lawyering abroad. We know that through the 20th century, litigation has been deployed actively as a strategy to champion human rights. Through the previous lesson, we read this strategy through the lens of Schoengold's analysis of the myth of rights and the politics of rights. Briefly, the myth of rights views rights as an ideology which shapes policies and inheres in individuals, whereas effective transformation, as per Schoengold, can be attained by translating the myth of rights into politics, by making it a matter or a subject of public consciousness, which also simultaneously shapes institutions and processes of the state. Through 20th century, human rights lawyering has been used actively not only to champion individual cases of redressal, but also to effect political mobilization outside the courtrooms or, as Schoengold states, translate it into the politics of rights. Human rights lawyering is impacted to a significant degree by the political climate it operates in. First, the political climate supplies the threats to which lawyering must respond. Second, the political climate provides the conditions under which this advocacy must take place. And third, the climate also supplies the legal regime which gives space for this kind of cause lawyering. Therefore, we notice with the variation in the political climate, human rights lawyering has not been used uniformly across the board. There are differing strategies dependent on the cause that it espouses and the climate under which it operates. Therefore, for instance, NGOs in USA have used test case litigation, by which one case is made an example behind which an entire cause is rallied. Second, maybe by way of class action suits, by which multiple individuals come together to raise a claim before courts of law. And the third, a very active example of which we view in India, is through public interest litigation or the PIL, by which social causes are litigated absent an individual claimant and on behalf of the public. Through the course of this module, we will review the experiences of human rights lawyering from abroad. Since the United States of America has a long history of such cause lawyering or alternative lawyering, we will delve in detail of such advocacy undertaken in the United States through the 20th century, through the work of the National Association for the Advancement of Colored People, or the NAACP, or the American Civil Liberties Union, or the ACLU, and several other such organizations. In the second part, we will dwell on the experiences of human rights lawyering that the third world has to offer, beyond the Western liberal political regimes, since they present an entirely different political climate within which to conduct advocacy. We proceed with our first part of human rights lawyering in the United States of India. Now, human rights as an ideology gained currency only over the past century, only over the 20th century. Significantly, it gained fervor only through the late 20th century. But advocacy through litigation predates the popularity of human rights as an ideology in itself. So, for instance, in the late 20th century, Belva Lockwood was a cause lawyer who advocated the cause of the women's suffragette movement and the right to an education in law and the right to practice before the law. Belva Lockwood, along with several of her other contemporaries, used litigation as a strategy by which the right to vote for women could be secured. She also went to court championing her right to receive a legal education and to be able to practice law. This arose from her own private experiences, where she was admitted to a reputed university of law but denied a degree after completing her education solely because she was a woman. Even subsequently, she was debarred from practicing before several courts across the United States of America, since their rules did not permit women to practice law. The rightful sphere of the woman was considered to be the home, tending to the family, and therefore courts there believed it detrimental to the interest of the society to permit women to practice law. But even as Belva Lockwood went to court over her right to practice law and over the right to vote, she simultaneously conducted her advocacy before Congress and lobbied for better rights for women. Gradually, as United States entered the 20th century, there was increased mobilization and advocacy efforts centered through civil liberties organizations. Human rights lawyering was first used sustainably as a strategy by civil liberties unions in the United States of America. So, this organized political action was undertaken most importantly by the NAACP against racism, by the American Union against militarism, against American participation in World War I and mandatory conscription, by the National Civil Liberties Bureau, which was the successor to the AUAM, and the American Civil Liberties Union. However, litigation was not always the preferred mode of advocacy of these organizations. The initial strategy focused on popular and congressional deliberation. The methods, therefore, were through lobbying, through institutional grassroots movements, through mobilizations and conversations. And this is because the role of the civil society organizations was not viewed in antagonism with the state. This was in keeping with the liberal paradigm, in which the law, the state, and institutions of the state were viewed hospitably as being able to accommodate rights for all and were not viewed as inherently violent or biased. Therefore, the limitation of the law was something that could easily be overcome through legal and constitutional deliberation in itself. The emphasis on congressional constitutionalism was viewed as a more democratic form of change, where litigation was viewed in an adversarial manner and antagonistically between different entities. For this reason, it was found to be largely unsuitable. This was more in line with Scheingold's emphasis on the politics of rights, where the focus is on the transformation of public consciousness and not necessarily through an antagonistic championing of rights through courts. We begin with our study of the AUAM. The AUAM, as I mentioned earlier, espoused pacifism. It was heavily opposed to Woodrow Wilson's policies of militarism in the face of the World War I, whereby through his policies, he was championing public opinion in favor of American participation in the World War. The objective of the AUAM was several-fold. First was to counter the war hysteria and propaganda of the Wilson government. Second was to protect the rights of conscientious objectors against conscription. Conscription is a practice by which men were demanded of mandatory military service and to serve in the war. Conscientious objectors, since being opposed to the war in the first place, were also opposed to conscription, since they did not want to participate in any kind of violent activity at all. And the third objective of the AUAM was to protect the civil liberties of those who opposed Woodrow Wilson's policies on the war. At this time, their method focused largely on their First Amendment free speech rights, where through speeches, through writing and public discussions, they sought to build opinion against the war and American participation in the war. As a side strategy, they also employed litigation for individual cases of conscription of conscientious objectors. The AUAM gradually paved way for the National Civil Liberties Bureau. The NCLB broke away from the AUAM to expand its mandate beyond pacifism to also include labor rights. Even at this stage, their main plank was to lobby with the senators to effect change, and litigation was a side strategy used to litigation was a side strategy. Even at this stage, their main method was to lobby with senators. Litigation was used simultaneously but as a side strategy. It was used for individual cases to gain redressal in individual cases, but also it was used as a plank to generate public opinion around a cause. Simultaneous with the litigation that was ongoing in courts, the NCLB organized mass meetings and public gatherings through which it could organize this public opinion, such that the trial in effect could be dramatized and the issue which was actually at trial could be put on stage. The NCLB led later to the ACLU, or the American Civil Liberties Union, with Roger Baldwin at the helm of affairs. While the prime causes that the ACLU espoused continued to be those of its antecedents, such as pacifism and free speech and labor rights, the time when the ACLU was operating witnessed a massive change in the political climate. This is because while ACLU's cause of pacifism and free speech still had large currency among the public, it was also gradually associated with unpopular causes of labor rights, which were more disruptive of existing political and social hierarchies. The fact that it was espousing such unpopular causes had a massive impact on its legitimacy in the public eye, such that their pieces of advocacy outside the courtroom were not as impactful as they had been earlier. Mass mobilization and lobbying was slowly ineffective. It was at this stage that the ACLU made a turn to litigation as its main strategy to pursue unpopular causes. As part of its strategy, it brought the Bill of Rights into central focus and aligned its mobilization around the Bill of Rights. This strategy was a leaf out of the book of NAACP. Through the past few decades, the NAACP had a lukewarm success with its litigation strategy. It was also one of the first organizations to set up a separate litigation department of its own to undertake its advocacy efforts through courtroom. The benefits of litigation at this stage was again to redress individual wrongs, to bring publicity to important causes, and to dramatize and make the trial a theatre in itself, where arguments and philosophies and politics could be deliberated at length. Now, the common network of advocates between NAACP and ACLU led the ACLU to adopt this litigation model as well. While the ACLU made individual interventions, it also propped a lot of its strategy on the method of test case litigation. Test case litigation was a way by which organizations could intervene in violations of new laws by individuals and citizens, take them to court and test their constitutionality by rallying behind that individual. This test case litigation could also be undertaken through a deliberate disobedience of the laws by the members of the ACLU itself, such that that violation eventually leads them to court, where they can deliberate upon the constitutionality of the legislation. Now, this strategy was of utmost significance because of the rule of the American courts on locus standi, or standing. What is it? What gives you the standing to come to court? The rules on locus standi were limited, because only individuals who had actually incurred injury on account of a legislation or an executive action could go to court. Organizations themselves, without actually incurring any injury, could not approach courts to discuss to test the constitutionality of the law. The most remarkable example of this test case litigation adopted by the ACLU was the famous Skokie trial. The Skokie trial challenged a Tennessee state law which prohibited teaching Darwin's theory of evolution in schools. This was a law that was not limited only to Tennessee, but across several other states in the USA as well. However, it was in Tennessee that a school teacher, Skokie, taught Darwin's theory of evolution in school and came to be in conflict with the law. The reason why this law was, to supply some context, the reason why this law was so problematic. To supply some context, the reason why this law was so problematic was because it was in opposition to the Christian doctrine of creationism. Creationism stated that God created life and human beings on earth. Darwin's theory of evolution opposed creationism and therefore was viewed to undermine Christian thought. So the Skokie trial brought to the fore the debate between religion and science. When Skokie broke the law in Tennessee by teaching his students Darwin's theory of evolution, the ACLU intervened and conducted the litigation in the name of Skokie. ACLU selected Clarence Darrow to represent Skokie in the trial. Darrow himself had a long history of public-spirited litigation, where he had earlier defended the rights of workers and the rights of death row prisoners before the US courts. But as the trial was ongoing in courts in America, it was actively supplemented by publicity, mobilization, public debate, and opinion pieces in the press. So through the Skokie trial, we see that ACLU tried a simultaneous operation of constitutional deliberation and courtroom constitutionalism. The dramatization strategy was at work, where litigation afforded the platform for a threadbare analysis of the politics and philosophy behind the issue of the Tennessee law, and the use of rhetoric for the formulation of opinion and policy. So we see that even in this remarkable example of test case litigation in Skokie's trial, it was supplemented by a simultaneous march within and without courts, which is unanimously echoed by human rights lawyers across the board as the most effective tool for transformation. Even McCann, in his study of equal pay for women litigation, states that even as litigation was not entirely successful in courts to champion equal wages for women within the workforce, it was deeply, deeply instrumental in transforming change eventually. One, because it was able to because litigation was able to bring the issues to light. It was able to generate significant public debate and opinion in favor of equality, which eventually paved the way for congressional change later. So this change in political climate, we notice, where the ACLU became unpopular, increased the reliance of the ACLU on the Bill of Rights to effect change on the ground. It is largely as a result of this excessive reliance on courts and human rights lawyering that the 1950s and 60s came to be known as the civil rights era in America. This witnessed a huge rise of constitutional and human rights litigation in US courts. It was on account of this volume of it witnessed a huge rise in constitutional and human rights litigation in US courts. It was on account of this volume of litigation on human rights that significant substance was supplied to the Bill of Rights through interpretations, doctrines, and depth. For instance, due process rights came to assume the centrality in public consciousness on account of human rights lawyering. It was also used in this time to champion freedom of religion, freedom of association. It was in the US courtrooms became an important site to champion equality for the sexes and for the different races, and to champion environmental causes. And throughout this time, legal interventions were made in several ways, either through individual cases, through class action suits, or even through amicus briefs supplied by the ACLU in litigations in which it was not directly intervening. But gradually, this strategy of the ACLU of using litigation as a tool to decide important questions of rights and liberties was tested significantly in the Skokie litigation. So far, ACLU had maintained an absolute stance on free speech rights of individuals. This came under heavy criticism, especially in the aftermath of the Skokie litigation, for neglecting the power politics that are actually at play in the exercise of these rights themselves between different communities. So what was the Skokie litigation about? Skokie was a small village in Chicago where 1 in every 6 residents was either a Jewish Holocaust survivor or a relative of exterminated Jews who were living in America to escape persecution that they were facing in Europe. The National Socialist Party of America sought to hold a march through the town of Skokie in their uniform with the swastika to hold anti-Jew protests. While the authorities prohibited the march for the sake of the Jewish residents, ACLU stood up to defend the absolute free speech rights and the right of assembly of this Nazi gathering. Consequently, ACLU succeeded in its litigation and the Nazi group was allowed to march through Skokie. But what was the impact this had on the politics of rights? 30,000 members of the ACLU left the organization in protest for ACLU's stance in the Skokie litigation, and the civil society groups were hugely divided on the actions of the ACLU and whether this was the right cause to espouse and in the right manner. Gradually, with the passing of the 50s and the 60s, came what Martha Minows later calls the waning of the civil rights paradigm. Now, through the mid and late 20th century, human rights lawyering focused on civil and political rights alone. For instance, Roger Baldwin refused to defend the free speech rights of authors and artists from censorship because in his opinion, the First Amendment protected only political speech. This not being political speech but only a method of creative expression was not protected by the First Amendment. With time, however, the work of these organizations on free speech and First Amendment came to encompass creative expression, issues of obscenity, hate speech, etc. as well. But the 1980s and the 1990s produced a huge skepticism on litigation as a strategy. This was with the Skokie experience was already behind America. But at the same time, civil society groups were also waking up to the constraints that the Constitution itself comes with. They recognized that the American Constitution and the Bill of Rights is constrained by its own history, by the time in which it was created, and the rights that it gave accordance to, by its own politics and by its own language. That gradually such excessive reliance on the Bill of Rights and through litigation in courts was found ineffective in bringing real change on the ground. Litigation was causing increased polarization in the absence of political and constitutional transformation. Furthermore, the movement was also limited by the resources at its disposal, and wondered whether litigation was the right avenue to channel its resources towards, or whether instead these resources should focus on political transformation outside of courtrooms. And with the ushering in of the 21st century, there was another radical shift in the political climate. There were new threats in the form of terrorism and in response national security. There were new threats in the form of, with the ushering in of the 21st century, there was also another radical change in the political climate. There were new threats in the form of terrorism and in response national security. There was also a renewed focus on illness, poverty and hunger as human rights issues, given the importance that was now also attached to the second generation rights. There were new conditions supplied by the political climate in the form of the security state, which had come up to deal with issues of terrorism, and the evolution and the further refinement of the neoliberal capitalist state. And then there was the new legal regime in the form of the expanded mandate of the human rights instruments to encompass economic, social and cultural rights as well. Martha Minow places all of this in context to reflect on the waning of the civil rights paradigm in the United States. She analyzes the manner in which the US Supreme Court gradually into the 21st century withdrew from social justice litigation. Through a string of cases, it limited its jurisdiction to in fact even hear civil rights claims. It simultaneously constrained congressional jurisdiction to legislate on civil rights. So for instance, in the case of United States versus Morrison, the Supreme Court held that the Congress cannot call domestic violence a civil rights infringement, and it cannot provide remedies to victims for protection. At the third level, it constrained the rules of locus standi even further. So in Lujan versus Defenders of Wildlife, it held that organizations cannot sue on behalf of injured groups. Then in Alexander versus Sandoval, it held that individuals cannot also sue on behalf of individual groups. The facts related specifically to a school that was practicing racial discrimination and segregation. Ironically, by preventing individuals to sue the school for its racially discriminatory practices, it now made it impossible for a repeat of Brown versus the Board of Education, which was a landmark decision in the United States of America, responsible for in fact ushering the civil rights paradigm in the first place. And at the same time, torture warrants and racial profiling was coming to be justified in the name of the security state. Through all of this, it was time that scholars and organizations came to question the liberalist assumption that all of their lawyering was focusing on so far. Whether the state was actually neutral, whether it did not have an agenda of its own, and whether its institutions could actually provide any room for remedy. we now proceed to the second part of this lesson and seek to analyze human rights lawyering in the third world. Here, the third world presents an entirely different paradigm for conducting cause litigation, owing to its different political climate. We are now talking about countries where human rights are not necessarily constitutionally enshrined, such as a document akin to the Bill of Rights could be invoked in the courts of law. Or even if they are constitutionally enshrined, there is massive resistance to the rights consciousness in politics, in law, and in communities. The role that the law itself plays in these societies is very different, since there are competing authority structures in the form of communities, in the form of traditions, in the form of families. Stephen Ellman conducts an extensive study of human rights lawyering in the third world, and he points out the significance of third world countries lacking a liberal democratic framework and how human rights lawyering can be conducted outside a liberal democratic framework. He asks, what is the extent to which the international human rights culture influences domestic movements for human rights in third world countries, and the role that lawyers play in carrying the movement forward? Because these are jurisdictions that witness a greater disjunct between the myth of rights and the politics of rights. Because rights are imagined as what courts do and not what policies and politics are arranged around. Institutions are more distanced from the rights ideology. And therefore, individual cases of litigation assume as much significance as public interest claims. Therefore, human rights lawyers in the third world engage on a sustained basis with individual cases instead of mobilizing specifically around test case litigation or public interest claims. Most of this work is conducted on an organized basis by human rights NGOs in the third world. Distinct from the first world, the activities of the third world lawyers are better described as an alternative lawyering because they employ a different methodology altogether. Their lawyering encompasses a broad range of activities. Here, community building is preferred over courts, and even when the law is resorted to, other legal avenues are explored in as much depth, such as through executive action, through alternative dispute resolution mechanisms, through legal literacy programs, and through paralegal trainings. Their endeavor is first to create legal empowerment within the citizens, such that they can access justice and access the law better. Through their endeavors, they seek to demystify the law and lawyers for the end users. So within courts, they engage with individual cases and cause litigation, and it is found that mostly in the third world, more than any other public institution, it is actually the judiciary that tends to be the most sympathetic towards human rights practices. In their methodology, as much as they deploy the domestic legal apparatus available at their disposal, they draw equally from an international human rights law framework as well. So for instance, in Nigeria, where organizations were striving to prevent death penalty for teenagers, they drew equally from domestic, regional and international instruments. Specifically, they drew heavily from the African Charter on the Human and People's Rights as well, through which we are able to notice how the practice of alternative lawyering in the third world is at a much wider scale and at a much wider scale to generate a political consciousness around the paradigm of rights. Thank you.